morning, and may it please the Court. Mike Mongan for the Attorney General. With the Court's permission, I'd like to reserve 5 minutes for rebuttal. The Supreme Court has recognized that not every type of weapon is protected by the Second Amendment, and that certain weapons, like M16s, may be banned. The statute challenged here restricts the capacity of magazines to 10 rounds without putting any limit on the number of lawful magazines or the amount of ammunition that gun owners may possess and use. That statute is constitutional at both stages of Bruen's framework. At the first stage, it's plaintiff's burden to show that large capacity magazines are presumptively protected under the original meaning of the Second Amendment. And that inquiry includes consideration of the objective character of the device and whether it's a self-defense weapon. The record here establishes that large capacity magazines are not self-defense weapons. These are especially dangerous devices that allow an attacker to maximize casualties with a huge volume of rapid and uninterrupted fire.
Counsel, which party bears the burden of proof at the first prong of the Bruen test?
I think we're in agreement here, Your Honor. The plaintiffs agree that they carry an initial burden. I think we disagree about what the scope of that burden is. That's consistent with sort of normal standards of civil litigation, and I think it's inherent or implied in the Bruen decision itself, which is quite specific that the government has the burden at the second stage. I think that implies that it's the plaintiff's burden at the first stage, Your Honor.
Counsel, I'm sorry.
I just was specifically with respect to the question of whether or not LCMs are arms. Who has the burden of proving that?
I think both parties agree that that burden is on the plaintiffs in the first instance, Your Honor.
I was going to ask, why isn't the first step a simple textual step, and the question for us whether a magazine or a large capacity magazine is an arm at all, or whether it's an accessory or something else?
Sure, Your Honor. I do think that that's part of the first step, but it's not the only part of the first step.
Why don't the other issues belong in the second step?
So, two answers to that, Your Honor, precedent and history. So as a matter of precedent, I think Bruen is quite clear on this. At page 32 of that opinion, it says you have to look at, is this device in common use today for self-defense, before it held at page 33 of the opinion that the plaintiff's proposed conduct was presumptively protected. This circuit's precedent said the same thing, and I believe that the dissenting judges on this panel at the stay stage recognized that common use for self-defense and the dangerous and unusual tradition go at the first stage because they bear on the original meaning of the Second Amendment. And
but how do they bear on whether something is or is not an arm, which seems to me the sort of going in question, or whether it is an accessory to a firearm?
Right, Your Honor. So I think we do look at the definition of arm, but as Heller and Bruen recognized, the Second Amendment codified a pre-existing right, and it's clear in the Heller decision itself in discussing the founding era conception of that right that it excluded certain types of arms. So I think that the common use for self-defense and dangerous and unusual inquiries are relevant in understanding what the original meaning of that right is.
Well, I'm still not sure you've answered Judge Gruber's question. At least you have. I'm still confused. Second Amendment does not protect non-arms, does it?
Well, I think it does not protect non-arms unless
Well, does it protect this?
I think what this circuit has said in Teixeira and other cases is it protects arms, and it protects certain other things if they are necessary to the realization of the core right to self-defense.
Fair enough. So I guess I'm stuck on what Judge Graber was asking you. If we were to determine that a large caliber magazine by itself is not an arm, it's not used to attack anybody else, and it's not necessary for the operation of a semi-automatic weapon, do we have to go further than that?
Your Honor, I don't think you do have to go further than that. That is our argument. I think that it may make sense to go further, as some courts, the Kotek District Court in Oregon, for example, answered that initial question exactly.
Well, sure, we can answer all sorts of questions, but I think what Judge Graber was asking you, at least in my mind, was whether or not that textual analysis requires us to look at history or common understanding or anything else, or whether it just allows us to look at the characteristics of the implement at issue.
I understand and I agree. I think that at that first part of Bruen's first stage, you can look just at the definition of arm.
But I want to be clear about your answer. If we answer at that first part of Bruen's first stage that this is not an arm, need we go any further?
I don't think you need to as a matter of the framework, no. But if you were to answer that it is an arm or falls under that ancillary protection, which is not our argument, then that would bring you to the other considerations, common use for self-defense and dangerous and unusual, which I do think are properly considered part of that first stage.
Dangerous and unusual, as it first appeared, and I think Heller, it said something like dangerous and unusual weapons, which I would have taken to mean dangerous weapons and unusual weapons, not necessarily dangerous and unusual weapons. Has the court backed off that and made it clear that it has to be both?
Your Honor, I don't think that the Supreme Court has ever elaborated on that in a way that would suggest that it should be understood in the sort of strict numerical way that my friends have suggested, i.e., their view is no matter how exceedingly dangerous a weapon is, if it is numerically prevalent past a certain point, then it's no longer unusual and it's outside that tradition.
So the common use criteria is really the unusual criteria. Those are the same.
I think they're closely related, Your Honor, but I'm not sure that they're exactly the same. And if I can elaborate, I mean, what Heller was trying to do was to invoke a tradition that was well known and discussed by commentators and treatises at the founding. And so I think it would be a mistake to look at those words dangerous and unusual, or dangerous or unusual, as Blackstone put it.
Dangerous or unusual, exactly. I mean, that's kind of puts a finger on the scale because and seems to mean and. But instead, the original phrase was a adverbial phrase for a noun, and the and just seemed to me was to say that it amounts to or, but it's not because and is or, it's because this was just a shorthand way of saying dangerous weapons and unusual weapons.
Well, Your Honor, if I can offer two responses. I think even if we were just parsing it sort of linguistically, I don't think it needs to be read or should be read in the conjunctive way that my friends have suggested, but I think the better understanding is that this was meant to refer to a historical tradition, and Heller said that, look, we're not exhaustively covering the history here, so if we today want to understand what dangerous and unusual refers to, we should look to the history, and it was always understood by those founding era treatise writers as referring to especially dangerous weapons. Sometimes, often in fact, the government acted after those weapons had become numerically prevalent because, of course, that's when they start to create real-world harms. That's exactly what happened, I think, with crossbows, which is one of the leading examples that treatise writers like Sharp were pointing to. These were especially dangerous weapons. They became prevalent in England, and at that point, the king, Henry VIII, decried them and said, now that they're creating real problems within the realm, I'm going to prohibit the possession by most of my subjects. And so I think that that's contrary to the interpretation that's been offered by plaintiffs, and we have to understand the Second Amendment in light of that original conception of the pre-existing right that it codified.
Counsel, as I see it, I think common usage is in both Step 1 and Step 2 of Bruen. I agree with you that common usage should be taken into account of what is an arm, but do you agree that it also has a place in Step 2 where if a state proffers a historical analog that prohibits something that's dangerous or unusual, do we then say, well, if it might have been dangerous or unusual back then, but given that it's common use today, it's not a proper analog? That's what I think Bruen was telling us.
Well, Your Honor, I'm not sure that I would characterize it that way, but I will grant you that, especially in a case like this one, where we're dealing with a dramatic new technology and a problem that didn't exist in the relevant historical periods, that you have to have a nuanced understanding of the history. I think if you get to this stage 2, we have a long tradition before and after the founding of governments heavily restricting and sometimes banning especially dangerous weapons. And Bruen teaches that you need to take a nuanced view of that history in a case such as this one. I think that the type of restriction that we're dealing with today falls comfortably within that tradition, and certainly if you proceed to the other questions that Bruen says we have to ask, does it comparably burden the right to self-defense? Is it comparably justified? I think we satisfy those points. I mean, the First Circuit, I think, just addressed this recently, but when you have a law like ours that does not restrict how many magazines, lawful magazines, somebody can carry, it does not restrict the amount of ammunition they can use and possess or how many shots they can fire, it just limits the capacity of a particular magazine. I think that in comparative terms, the burden on the right to self-defense is much less than some of the historical analogs where governments looked at particularly dangerous weapons and banned their possession altogether.
I have a question about the analogous issue. There is a case in front of the Supreme Court now, Rehearing, that does not concern the nature of the weapon or its accessories, but concerns who can possess firearms, and it deals with domestic violence, as I'm sure you're aware.
Yes.
But in that context, in your view, should we wait for the Supreme Court's opinion on the theory that it might shed light on just how analogous the analogs have to be?
Your Honor, certainly that case addresses some of the aspects of the analogical framework established by Bruen. I think it could shed light on the analysis here. I think we can safely expect that that decision will come down by the end of June, and yes, it may be sensible for this en banc panel to await that decision before finally deciding this appeal. Whether that's done informally or through formal abeyance, I would defer to the court, but yes, I think it could shed some light.
Counsel, can I ask a question? You agree that we've already issued a decision in this case in 2022, this en banc court, right?
There was a prior appeal, and that case was decided, yes, and then it was...
And this is a new decision that we're issuing in light of Bruen, correct?
This is a new appeal in the same case or controversy.
Okay. And that seems to be the problem with your argument under Section 46, is you only look at the language about case or controversy. But the case or controversy language seems to be a prerequisite, true, but then it says the same panel, senior judges are only able to serve to issue the decision. And as you just acknowledged, this is a new decision. Section 46 does not say senior judges are able to serve on all subsequent decisions in the case. Why doesn't that answer the question about whether this en banc panel has statutory authority?
Sure, Your Honor, and we've studied this closely since the court's briefing order. We do think that the en banc panel's decision and its application of General Order 3.6b is consistent with the broad authority granted by Section 46C. Let me address directly your point about that final clause in, I think, subsection 2 of 46C. I think that language has to be understood in context. So if we get down there, we're in a case where a majority vote of the active judges has already happened within that case or controversy. An en banc panel has been constituted. And then what subsection 2 says is that a senior judge who was active at the time of that initial vote here in 2021...
That's not what the statute says. The statute doesn't say active at the time. The statute says active at the time that the case was heard or reheard. This is a rehearing of the same of a prior case. So I think we need to stick to the statutory language and explain to me how this is not a rehearing and why the judges don't need to be active at the time this case is reheard.
Well, Your Honor, I think that just focusing on the text of the statute, it says that the en banc panel shall consist, in this circuit, there's an exception under 92 Statute 1633 of a number of judges as prescribed in accordance with that law, except that any senior circuit judge of the circuit shall be eligible, and then to subsection 2, to continue to participate in the decision of a case.
Isn't that the point? Continue to participate in the decision. And you just acknowledged that if anybody had taken senior status, and I think they did, before the first decision was taken, that would be covered by the statute. But this is a new decision, as you just acknowledged. So how can senior judges continue?
Could you continue with the rest of the subsection 2?
Sure, Your Honor. And with respect, I think I just read this differently, and I'll try and explain how I come at it. So subsection 2, to continue to participate in the decision of a case or controversy that was heard or reheard by the court in banc at a time when such judge was in regular active service. I'd like to address both the decision, the singular that you focused on, and case or controversy. So case or controversy is a term of art. It has broad meaning to extend to the entire adversarial dispute between the parties, not just an appeal. And I think that when Congress says the decision, it's common that there may be multiple decisions or orders or actions in the context of deciding a case or controversy. Indeed, Your Honor, as plaintiffs have noted, in the prior appeal, there were multiple decisions. I don't think it's sensible to read subsection 2 to say that a senior judge only gets one shot to serve on an en banc panel.
It's not only one shot. It's till the decision is final.
I have a follow-up question that I'd like to ask, actually, both counsel to answer. Clearly, this is a very important case, and we actually have never taken a case to the full court en banc. But that would appear to be, under our general orders, the next potential step. What is your view as to whether we ought to do that in this case? And that would moot this issue that has been raised, and it would ensure that whatever decision comes out would reflect accurately the entire court's view.
Your Honor, we haven't taken a position on that. It's certainly an option. If the members of this court thought that was appropriate to consider full court en banc, I would defer to the judgment of the court on that.
If we did that, counsel, would the senior judges currently on this panel be able to serve on that full en banc panel?
Your Honor, I don't know. We haven't briefed that.
I think the answer has to be no, because we'd have to take a new vote and they wouldn't be able to serve, which begs the question, how does a limited en banc court get composed of judges who couldn't even sit on the full en banc court? It seems to undermine the entire statutory construction of the en banc process.
So, Your Honor, we haven't briefed that. We weren't asked to brief that. I'm not sure that I read the general orders that way, although, obviously I'm a little bit hesitant to describe your own general...
We don't need to go to the general orders. The statute says the only time that a senior judge can serve on the en banc court is if they were on the three-judge panel. None of these senior judges were on the three-judge panel. So if we go to the full en banc court, I don't know what the statutory basis would be, other than just ignoring the statute, to allow the senior judges on this panel to serve on that panel.
Can I ask a question?
Yes, of course.
Why do you say that there was a decision in this case? There wasn't a decision in this case. There was a decision, but it was vacated, so there was no decision. It was then remanded essentially as what we call a limited remand to get some information so we could continue to make a decision. But there was no decision by this panel that actually concluded.
Well, Your Honor, I will grant you that. I guess I was referring to the initial decision, which was vacated, and then the subsequent decision for the remand.
So whether there's a decision is there hasn't been a decision by this court on this issue.
I guess that could be debated. I guess the point that I'm trying to make as I come afresh to this statute and issue is that I don't think it makes sense to say that by referring to the singular, the decision, that means that only one decision is in play. It's referring to the...
There has not been a decision binding on this court on this case or controversy.
Sure, Your Honor, and I think even if we take that view, the interpretation that I'm advancing, it would still suggest that the en banc panel's decision to keep this case is consistent. And, Your Honor, I guess the other point that I would make, I think if you look at the history of the statute, obviously we have different interpretations of it, but I think what is clear under Western Pacific and other cases is that this was meant as a grant of authority to the circuits to devise policies and procedures that they view as sensible.
Well, I don't disagree with that. It certainly expanded what existed in 96. The question is how far it expanded it. And I have a hard time envisioning that Congress sat there and thought that when this comes back from the Supreme Court, if we get reversed again, that we're going to sit here and we're all going to, be these 11 judges are going to be the arbiters of the Second Amendment forevermore in this court. That doesn't make sense. And it seems very inconsistent with how the en banc process was set up. As you acknowledge, it is intended to allow the active judges to set the policy of the court.
Well, Your Honor, I guess if I can just make 2 points, and I do want to make sure that I save some time for the other constitutional questions in this case. I think, first, it is envisioned in the statute that the circuit would set policies and procedures. 3.6b has been part of the general orders, but of course the court in its normal procedures could address some of the concerns that have been raised by some members of this en banc panel and change that. We've just been asked to brief the statutory question. And second, Your Honor, I think if you're asking, well, why would the court or why would Congress want to have a scenario where an en banc panel can keep a comeback case, I think that this case is a pretty good illustration of that. I think we understand that there are efficiencies sometimes to have a panel keep a case, and here we've got an appeal arising out of the same motion on the same claims, same parties, substantially similar record.
I would agree with you if case or controversy were the only language, but I think we've probably gone as
Can we go back to the to the first point?
Yes, of course, Your Honor.
Yeah, and this is an interesting question, but I'd like to get back to the merits. So one of the arguments that the plaintiffs make is that these magazines are integral to the operation of a semi-automatic firearm, right? And they also point to California's statute that apparently requires that a user, an owner of such a weapon, has to have a device that allows the magazine to automatically be disconnected. So in that context, why isn't the magazine sort of like entitled to some sort of corollary Second Amendment protection, or why isn't it all sort of fit together?
So, Your Honor, I want to answer that, and then I do want to address some of the objective characteristics that we think are relevant here. So we would agree that for most semi-automatic firearms that accept detachable magazines, they need a magazine in order to function. And so, as this court has recognized in Teixeira and FIOC, that some type of detachable magazine would come within that ancillary protection. I think where we part ways with the plaintiffs is that we think the record here is undisputed that every semi-automatic that can accept a large capacity magazine can also accept a 10-round magazine and function as
Can I ask you a question
intended.
about that? Because
Yes, Your Honor.
So the way you're treating magazines, it seems like you could use the same sort of rationale as between a non-semi-automatic firearm, say a lever action or a bolt action or a revolver type action, and a semi-automatic firearm. So I'm trying to figure out if you're saying, well, what we do is we say, have people ever banned particularly dangerous rounds? And now we're saying large capacity magazines are particularly dangerous. Why couldn't that same reasoning be used to ban semi-automatic firearms altogether? To say, because think about it, like during the Revolutionary War, if the United States had semi-automatic firearms that only held 5 to 10 rounds, it'd have been about 10 minutes and it would have been over, right, as against muskets. So clearly the semi-automatic mechanism is way, 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 way more particularly dangerous than the delta between a 10-round magazine and a 15-round magazine. So why does your reasoning not mean that, if this reasoning works, why does your reasoning not mean that a state could just ban the semi-automatic firearms altogether?
So if we're just start talking, Your Honor, about this initial sort of textual question, I think if you're dealing with a semi-automatic, that would fit the definition of an arm.
No, but that semi-automatic could be a revolver. Like it could be, just like that high-capacity magazine could be a lower-capacity magazine.
Right, Your Honor. So I think that would fit the definition of arm, and then you'd move on to the other aspects of the Bruen analysis. At stage 1, is a particular weapon that's being addressed by the law in the tradition of dangerous and unusual? Is it in common use for self-defense? And we think Heller is clear that has to consider the character as well as the numbers.
I'm not understanding I think I'm missing your response to it seems to me that just as you could say, are you saying that yes, so it would be an arm under, you're not conceding that it would be an arm under stage 1. So why are you saying it wouldn't be an arm, but the semi-automatic versus revolver, say, distinction is something that we're stuck with? You would agree that you can't ban the automatic mechanism.
Well, an automatic mechanism, I think that you can ban. I think the Supreme Court has recognized
No,
that
the
as
automatic
someone-
mechanism is a term that semi-autos and full autos use an automatic mechanism.
Sure, Your Honor. I'm sorry for the confusion. No, I don't think that we could ban all semi-automatic weapons. I think Heller makes that clear. The point I was just making is, with respect to accessories, I think we have a difference of opinion where my friends suggest any accessory that is somehow helpful to armed self-defense.
So that's important, because your argument turns on whether you can characterize accessory. So you would say that the revolver versus semi-automatic is not an accessory, but that a magazine is this accessory. So what would you think about like a red dot sight, electro-optics, which many firearms are going to electronic optics nowadays. They're obviously an accessory because you could have iron sights. Could you ban those?
Well, so, Your Honor, I'm not intimately familiar with that, and I do want to answer this question and make sure that I save time for rebuttal. I think that the question at the outset would be, is that, if it's an accessory, is it within the Teixeira principle that it's necessary to the realization of the right to self-defense? And you'd have to build a record and analyze it in that case.
So, counsel, you're saying
briefly
that
address the history questions on the assumption that this is an arm?
Yes, Your Honor. So we have a long and established tradition in this country, and before and after the founding, that with respect to especially dangerous weapons, those have been heavily regulated and at times banned. And that often comes about after they have become sufficiently prevalent in numerical terms that they start to create real-world problems.
So what do you end up doing with the common use notion? I mean, whether it's in the front end or the back end, is your essential answer is that it cannot drive the conclusion, or what exactly?
Right. So I think that
there are lots of these things. Okay.
Yes.
So but it seems like they are in common use. Maybe they're not in common use for self-defense. That's one possibility. But what else?
We think that numbers alone are not sufficient, Your Honor, and I think that this follows from Heller. That Heller said you have to examine the character of the weapon, not just the numbers or subjective statements about people's preference. And when it looked at handguns, it actually focused on the objective features of those weapons and what made them helpful in ordinary self-defense situations. And I think it's a fair inference from Heller that with respect to something like a fully automatic machine gun or an M16, the court was inferring that the objective characteristics of those weapons were not self-defense weapons. They made them offensive attack-style weapons that maximize deaths and fatalities and casualties in an attack situation. And I think that that has to be considered, because if you just looked at the numbers alone, it would, as the Seventh Circuit has indicated, create some real circular and absurd consequences. I mean, just take machine guns. I still haven't quite heard an answer as to whether my friends think that machine guns are constitutionally protected. Heller said it would be startling to think so. But if we accept their sort of numbers-only approach, I think there's only two possible scenarios. One is they already think that these weapons are protected because by some measures there's 176,000 of them in civilian hands. Or the other alternative is they are not yet protected but on the cusp of protection, and the only thing that's keeping the federal ban on machine guns constitutional is that ban itself, which prevents more civilians from purchasing machine guns. That is not a sensible way to understand the Second Amendment. It's not consistent with what Bruen did, because Bruen didn't look at numbers when it said that sawed-off shotguns and machine guns can be banned, and it's not consistent with the history, because if you look at the founding era treatises and historical examples, those aren't saying that the ability of the government to regulate or ban especially dangerous weapons just disappears when they become more prevalent in society. Your Honor, I do want to make sure that I have some time to...
Yes, I'll give you some time, but before you step back, let me just ask Judge Ikuda if she has any questions for you.
I do not. Thank you.
Okay. Thank you.
Good morning, Your Honors, and may it please the Court, Erin Murphy on behalf of the plaintiffs. Tens of millions of law-abiding citizens across the country keep and bear magazines capable of holding more than 10 rounds for lawful purposes like self-defense. Under the Supreme Court's decisions in Bruen and Heller, that forecloses California's effort to ban them because the court has been emphatic that our tradition is one of protecting the right to possess arms that are in common use today. The state's efforts to resist that conclusion are fundamentally incompatible with what Heller instructs and Bruen instructs are the definition of the term arms and the historical tradition about what kinds of arms the state may ban consistent with the Second
Is your
Amendment.
position that the number of these that are out there now is the answer? That's simply once there is past a certain number, whatever that number is, they're in common use and you cannot ban them. Is that your ultimate conclusion, no matter what else may be true?
They have to be commonly possessed by a common number of people for lawful purposes like self-defense. So there is
self-defense or for self-defense?
The language of Heller is like self-defense, so self-defense certainly counts.
But I thought self-defense was the whole premise of the Second Amendment protection.
Yeah, and I'm happy to, I think here it doesn't really matter whether you can go beyond self-defense because these magazines are just unquestionably in use for self-defense in the manner that Heller contemplated and Bruen after it, because Heller analyzes that question in terms of whether something is typically possessed by law-abiding citizens for the lawful purpose of self-defense.
So if the Brady Bill had remained in effect and there were the number of these weapons, of these magazines had atrophied and they were no longer in common use, then they would have lost their protection?
No, I don't think that's right because I think that law was unconstitutional when it was passed. And if you take something that's already in common use...
Somebody had passed a national law in the 1930s, that would have been the end of it?
No, I think that if you look historically at how this actually worked with respect to machine guns, it's a great example. Machine guns didn't come on the market until 1921, and people didn't really want them. The state's own expert talks about how the company that made them was only able to sell about a third of them, and within 4 years, states were banning them all over the country. And by the time the federal government came along in 1934, more than half the states had already enacted bans or severe restrictions. And I think that goes to show that this idea that there's no content to the common use test is belied by history. People actually do make decisions about what comes on the market, and when that came on the market, the widespread reaction throughout the country was, this is different than the semi-automatic firearms that have already been on the market for 40 years. We can articulate what is different about this technology.
Counsel, what's your response to your friend's argument that there's, I think, 700,000 machine gun licenses out there in the world right now? That seems like a pretty big number.
It's a decently big number. I mean, obviously it's bigger than the number Justice Alito talked about in Catania. We don't have any real analysis of the manner of the kind of typical use question there. How many of them are really owned more as kind of a novelty or something that can only be used under very, very strict circumstances at particular places, as opposed to actually being kept and used by people for self-defense. Nobody's tried to make a record on that.
So, counsel, it sounds like you're agreeing that common use is connected to self-defense. It's not just that they're common in number, but they're commonly used for self-defense. So, and there is a record about that, and there's evidence about that.
So I think the state and I have a fundamental disagreement about what use means when it comes to use for self-defense. Heller speaks of use as possession. It ties use to the concept of the Second Amendment itself, which the Second Amendment the Second Amendment itself doesn't protect the right to engage in self-defense. That exists independent of the Second Amendment. The Second Amendment protects the right to keep and bear arms,
right,
to have them at the ready for self-defense.
Yes. So if someone is trying to attack your home and you are holding a semi-automatic weapon with a magazine of 10 rounds and someone else's home they're holding a magazine with 20 rounds, in terms of how the intruder visualizes that deterrent, how is that any different? Do you understand my question? In other words, merely carrying the weapon with a magazine in it, ready to fire, is the deterrent. I don't think the intruder is looking at the number and counting them out. So why isn't it equally usable for self-defense with a 10-round magazine?
Well, I don't think that's the relevant legal question, is whether it's equally usable. It's an arm if it's usable at all, and it's in common use if you're keeping and possessing, if you're keeping and carrying it for self-defense, to be ready to engage in self-defense. If you tried to have a
But
test,
it isn't the size of the magazine that makes it a deterrent.
It may or may not be.
It's the existence, isn't it?
I mean, it all depends on the circumstances. It could make a big difference in some circumstances.
Counsel, if
to
that's
have
the
a larger
analysis,
magazine.
why wouldn't you be able to ban semi-automatics? Because as long as somebody has a revolver, I'd say you're pretty scary if somebody's trying to break into your house.
And I think the problem gets even more significant than that, because as we know from the studies that are in the record, I mean, there's about 1.65 million self-defense incidents a year. In more than 80% of them, no firearm is fired at all. And so if all that counted was that you actually fire a certain number of rounds at somebody, I mean, once you even get inside that 18%, it's a very small number that involves rifles. And once you take out the semi-automatic rifles that California thinks are not covered by the Second Amendment anyway, I think you end up having to follow that train of logic to say that non-semi-automatic rifles aren't commonly used enough to be covered by the Second Amendment, which cannot be consistent with Heller.
Counsel, does it matter how dangerous and unusual it is, in your view?
If it's dangerous and unusual at the historical tradition test, that necessarily contemplates it's not in common use today. I mean, that's what unusual means, not in common use. The court specifically contrasts the language when talking about dangerous and unusual of in common use as opposed to highly unusual in society at large.
So, I want to make sure I understand. Are you saying dangerous and unusual together, or dangerous and or unusual?
So I think Justice Alito is right that it's a conjunctive test, dangerous and unusual. It has to be both of those things.
And do you have any other?
That's not, as I said before, where this language generated from. The language generated as a adjective for weapon, and it essentially meant, or could easily have meant, dangerous weapons and unusual weapons.
Sure, but I do think we have to take what the Supreme Court has said about it, and
That's
the
what I
Supreme
said.
Court,
Yeah.
the Supreme Court has articulated when the Supreme Court talks about the dangerous and unusual test, it contrasts the concept of in common use today with highly unusual in society at large.
I understand that's the unusual part, but it doesn't mean it has to be dangerous, both dangerous and unusual.
I don't see.
Now, is there anything in the Supreme Court opinions that says that?
Well, what the Supreme Court said, I mean, it was critical to the holding of Heller that the court said that the state cannot ban arms that are in common use today. That had to be resolved because there was a debate in the case.
You're not standing on the notion that it has to be both dangerous and unusual.
Yes, in order to be banned, it has to be dangerous and unusual.
But what's your authority for that? I'm trying to figure out what the authority is for that, because from what I can tell, besides Justice Alito's concurrence in Citano, I'm looking for some other authority. Do you have it?
Sure. I mean, the Supreme Court didn't address specifically that question of whether it's a conjunctive test in Heller and Bruen, but the language that they use when they're describing the tradition, what they say is we derive from the tradition of the ability to ban arms that are dangerous and unusual, that you can't ban arms that are in common use at the time. That's the principle they're deriving from the tradition. And so the way the court is understanding the tradition is even if they might be dangerous, if they're in common use today, you cannot prohibit them. Now, I would also happily talk about the problem is even if you didn't think that question was already answered, the state would need to demonstrate a historical tradition that justifies banning arms that are in common use today, and they just haven't done that work.
Counsel, I would like to ask you the same question I asked opposing counsel. Should we await the Supreme Court's decision in Rahimi, which may further illuminate just how analogous an analog has to be instructive in this context?
So I don't think it's necessary in this case because
I didn't say necessary. Is it a good idea?
Here's why why I don't think it would be as useful in this particular case as in others, because we believe that the Supreme Court has already told us what the historical tradition is when it comes to the ability to ban arms. And that's not a question that's going to be addressed in Rahimi, and because the court has already said what the tradition is.
But there is considerable uncertainty, at least in my view, as to just how similar a historic practice has to be for it to translate to the current day. And domestic violence, it seems to me, would raise that question also, because I don't know that we had those laws, at the founding, and we do now. So wouldn't it illuminate at all this issue of how close the analogy has to be?
I think it could illuminate that. The sole point I was trying to make is our position in this case is that you don't actually need to get to go look at analogs, because we believe the Supreme Court has already done that work and told the courts what the historical tradition is when it comes to...
Are you saying this historical tradition comes in at step one?
No.
So let me just pose a hypothetical for you. Let's assume it was 1965 and the California legislature, in an unusual burst of prescience, enacted the same legislation we now have in front of us when large caliber magazines were not in common use.
Yeah.
Would that be okay?
So I would say no, and here's why, because
what I'm having trouble with is it seems to me that a constitutional act can't become unconstitutional by virtue of subsequent common use. So I'm trying to figure out why common use solves both problems.
And I'd like to make 2 points. I mean, first, just on that very specific point, I mean, Bruen pretty much says the opposite. Bruen says even if this 1860 or 1686 New Jersey ban on pistols really was a ban and was permissible because they were dangerous and unusual then, that wouldn't make the law constitutional today.
Let's go back to machine guns to make the question easier.
Well, actually,
Answer the question.
On your 1965 question, here's why I would say that that's still unconstitutional. In order for the state to come in and ban something that's new, that isn't,
not in common use.
It's not in common use just by virtue of it being new. I think the dangerous and unusual test is best understood as the state also has to show that what it's banning is materially different in some way that makes it unusually dangerous vis-a-vis the arms that are already in common use today. And so if, all the arms only had 10-round magazines because no one could figure out how to make 11, and tomorrow, someone figures out how to make 11, I don't think that means the state can just come in and say, well, 11's higher than 10, so we'll ban them immediately, no one can ever have them. They need to demonstrate that an arm with a magazine that holds 11 rounds is actually somehow meaningfully different from an arm that holds 10.
If machine guns today became in common use for self-defense, would the congressional ban of them become unconstitutional?
If we actually had some movement to lift all the machine gun bans...
No, I'm not just talking about any movement.
Well, there has to be, though.
There are 700,000 machine guns legally possessed in the country today. There's the capacity for many more people to get them because they can be licensed to get them.
Well, actually, at this point, you really can't. I mean, it's really
Okay, so what if those 700,000 people commonly use them for self-defense? Would the statute become unconstitutional because... No, let me finish because of subsequent use of self-defense, common use?
As I read the specific statement in Bruen, when they say, even if handguns were dangerous and unusual in 1686, they're not today, and what matters whether they're in common use today, that is what the court said. They were confronting that very question and saying, if something actually becomes in common use that didn't used to be, it does become protected. Now, I think there's a reason this is hypothetical. These bans have been in place for a century.
Can I ask a question? According to your briefing, as I read it, common usage is only applied in step 2 of Bruen. Is that right? Because I think I might disagree with that. I think it seems like Bruen says that common usage could be used in the definition of what's an arm, and it could be used in whether or not it's a proper analogy to historical legislation.
I don't think that's right, because the court speaks very specifically about the definition of arms.
Yes.
And the first test is just plain text, and the court's definition of arms, just as its definition of bear didn't admit of any distinction between public and private carry, its definition of arms, which is just something you can pick up and use for self-defense, doesn't admit of any distinction between how commonly something is used for self-defense.
But then if you...
But as a historical matter, the only arm protected by the right is those that are not dangerous and unusual and in common use, right? So why wouldn't it go into what's the definition of arm?
Because I think at that point, you're baking the historical tradition into the front end of the analysis. The court instead, if you look at when Bruen is articulating how to do historical tradition, it talks a few times about the dangerous and unusual test, and it specifically says, I mean, it uses the phrase historical tradition to refer to that repeatedly. It says, we found it fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons, that the Second Amendment protects the arms that are in common use today. It then goes on later and says, drawing from this historical tradition, we explain that the Second Amendment protects the arms that are in common use today.
It's a very historical tradition that changes depending on what people's personal choices are over time. That doesn't sound like history or tradition. It sounds like people's contemporary decision-making.
With respect, I disagree. I mean, the reason I think the court was able to coherently say what it said about the 1686 law versus today is the historical tradition is the principle, the rule of law that arms that are in common use today are protected. The application of that rule of law to the facts of today may have different consequences than it did 100 years ago or 200 years ago.
The Bowie knife statutes, which I gather were pretty prevalent when the knives were pretty prevalent.
Here's the problem with the Bowie knife statutes. There are not possession bans. They are the way that states regulated in response to concerns about Bowie knives was concealed carry laws. And many of those are the same concealed carry laws that by their terms also apply to pistols and handguns. And pistols
this is
and
not a
rifles.
possession ban of an arm either. It's a possession ban of an accessory, isn't it?
No, we do not agree that this is an accessory. A magazine is a functional component of a firearm.
But a large capacity one is not. A 10-round one will make all of the, according to what I understand from this record, it is almost universally true that a weapon that will take a large capacity magazine also will take a 10-round magazine.
I'm happy to accept that because I don't believe the test is essential. It's a functional component. Just because a magazine it's what actively feeds the ammunition into the firing chamber so that the firearm can fire. Pretty much all firearms, ever since we got past one shot, have some sort of ammunition.
Well, they all have ammunition too, but we have bans on certain types of ammunition. For example, you normally can't hunt in certain areas with lead shots and hollow point bullets and that sort of thing. And it's required for it to be a firearm, but it doesn't mean, does it, that there's no regulation?
Well, for purposes of this discussion, I think we're just talking about the threshold textual inquiry of whether something qualifies as an arm. Of course, you'd then have a historical tradition analysis of the regulation, but a magazine doesn't cease being a functional component of the firearm just because it has 15 rounds instead of 10.
What about an ammunition belt?
It's still, it's an actively functioning part of...
Sam, let's assume that you're right, that there's no historical tradition of regulating this sort of thing. So is it your position that an ammunition belt that held several hundred rounds of ammunition could not be banned by the state?
No, I think it probably could because as a practical matter, you're going to have, at a certain point, types of ammunition feeding devices are not in common use because they're impractical. People can't actually bear them and use them.
But under your answer to my previous question, as long as people started buying them today and bought enough of them between now and the time the state banned them, it would be okay.
As a legal matter, yes, but I think there's a reason. These are always hypothetical questions. These types of technology exist, yet people don't choose to arm themselves with grenades. Like, people don't all have 100-round drums that are super cumbersome and tend to jam a lot. People tend to make reasonable choices. Technology has been around for 100 years that people don't choose to keep and use in their homes for self-defense. So it's all well and good to talk about a hypothetical world where they don't, but...
My understanding is that one reason that these larger magazines are so prevalent is because when you buy the gun, it comes with those magazines. So people aren't making choices necessarily, they're just getting them.
That's only accounts for some of it because typically people, if you look at the study by Professor English, typically people have more than one magazine, so they're making choices about what additional magazines to get. And there are firearms where you could ask for it to be in a smaller round, or you could purchase a different firearm, but people choose.
It appears that the marketing has a lot to do with these choices.
I don't think that's really
Is it generally true that marketing will have a lot to do with the choices?
I mean, marketing has something to do with the choices, but they can't. The manufacturers can't force people to go out and buy AR-15 rifles. People choose to buy them, and part of the reason they choose to buy them is because in states that don't have restrictions like California's, they come with 15 or 30-round magazines, and people want that to defend themselves in their homes. Same with many of the popular handguns on the market today. Many of the most popular ones, people choose them because they have higher capacity, not magazines, not in spite of the fact that they do. But I also think, if you look at Professor English's study where he's looking at also people buying additional magazines, and people can buy different things, and this is what people, given the freedom that they have in most of this country to make their own choices about what they want for self-defense, I mean, roughly half the magazines that people purchase in this country, well over 100 million, are magazines that are unlawful under this law. And I don't think at that point you can really dispute that those numbers, wherever the limit, the cutoff is for common use, when you're talking about something hundreds of millions owned by tens of millions of people for the purpose of keeping them in their homes for the lawful purpose of self-defense, I don't see how you can really dispute that that satisfies common use. And in a sense, I don't think the state really does. It just wants to change the meaning of use and not focus
counsel,
on any of that evidence.
So going back to the dangerous and unusual, trying to decouple that, if we decouple that, then you get rid of the unusual, I guess, and then you get into the just dangerous. But of course, every firearm is dangerous, so it seems to me like you'd have to have some threshold of dangerousness. And I'm struggling to think of how that's done in a way that doesn't involve some sort of balancing that starts to feel like the test that the Supreme Court threw out in Bruen. So can you speak to that? It seems like if you're going to decide that a certain type of firearm is too dangerous, say a semi-automatic, right, but a revolver is not too dangerous, even though both are dangerous, and the state is going to have to say why the one is dangerous enough to satisfy their view of how Second Amendment scrutiny works, and that starts to feel just like the same old balancing we used to do in the bad old days.
I think that is the problem with trying to focus on it independent from common use and say that even things that are being commonly used are too dangerous for the people to have. The other thing that is particularly problematic about the argument that's being urged here is, for the most part, the state is not arguing that these are unusually dangerous in the hands of law-abiding citizens. Its argument is that they're unusually dangerous in the hands of people who want to commit mass murder and other horrific acts. But every firearm is incredibly dangerous in the hands of someone who wants to misuse it.
Yeah, so under that sort of
analysis, you take that
analysis,
logic, and I don't know what's
right.
left.
So under that sort of analysis, assuming that these horrible mass shootings went down, but crime went way up, it seems like you could rely on that as making just regular firearms.
And I think it's quite notable that if you go back to Heller, I mean, these aren't new arguments. These are the arguments that were being made in Heller. There were even amicus briefs there making the argument that one of the reasons handguns shouldn't be protected is because handguns are the weapon of choice for people who want to commit mass murder. And of course, much of the case was focused on criminal use, and the Supreme Court didn't deny any of that. It didn't say you're wrong, we don't think you've made a good record that people use handguns for criminal purposes. It said the Second Amendment has struck a different balance, and it takes off the table arms bans.
Can we turn attention to the jurisdictional question?
Absolutely.
So as I understand your briefing, the case you argue that this is a new case or controversy mainly because there's a new case number. That's somewhat unsatisfying as a cutoff. How did you get to that definition?
I think that really what the dialogue that was occurring earlier about the decision, the hearing and the decision, is key to it all. The statute.
But there wasn't any decision.
There was a decision. This
It
court
was vacated by the Supreme Court. So
this panel does not have, or this court does not have a final decision on the question of whether this California statute is valid or not valid.
That is certainly correct, but that doesn't mean this court didn't issue a decision. This case came back to this panel. This panel debated whether to decide it on the merits. We actually urged the panel to decide it on the merits.
Did you tell us that we didn't have jurisdiction?
We didn't think you did. We're lacking jurisdiction at that point.
But isn't the answer to that the mandate hadn't
the mandate
issued?
had
So we could have decided it coming back.
What's significant about the mandate?
Well, if I can take you in order. So there wasn't a once there was a GVR, there was no decision. because the court vacated the decision. Right. And so at that point, the hearing is still pending with no decision. But then this court issued, I absolutely appreciate that this court chose not to decide the case on the merits. But this court
so had we simply retained jurisdiction and remanded rather than giving it a new appellate number, would the answer be different?
I don't think it would have been consistent with Rule 46, Section 46C for the court to do that.
We often do that when we send something back to a district court.
I appreciate that, but I do think in the context of Section 46C, since it contemplates that all decisions about whether to have a hearing en banc need to be made by active judges.
It was long ago. That's what we issued in 2021. But let me ask you the same question I asked opposing counsel. What is your view on whether this should, due to its importance and to your concerns about whether we ought to hear it as a limited en banc, whether this should be a full court decision?
I mean, I certainly enjoy participating in the first ever full en banc sitting, but I don't know why the court has to go to that step.
I didn't say we had to. I'm asking your view as to whether it's a good idea.
It seems to me the logical course would be to start with the ordinary procedures of take a full court vote.
That sounds a lot like judge shopping. If you had a full court en banc, you would get, by definition, the real view of this entire court about this question. Why isn't that a good idea?
I mean, it's perfectly fine, and it's the prerogative of this court. I've just happened, as a historical matter, the court has never done that and gone straight to that, and so I would think in the ordinary course, I wouldn't consider it judge shopping. I would just consider it following this court's ordinary procedures to start with the 11-judge panel.
If we were to have another vote of the active judges and they voted to take it on bank, would this be the panel, or would it be a different panel?
No, I think you'd have to have a new panel.
Why is that?
For one, I think that the voting contemplates that then you have a new panel, but I do think that independent of the issue about the vote, the final clause of the second sentence of the statute precludes the active judge, the senior judges, from participating in the hearing, because the senior judges can only participate in the decision if they were active when the case was heard.
Of a case or controversy. There hasn't been a decision of the case or controversy.
There is.
It was heard. No, there hasn't been.
But
there might have been a decision on. Well, there wasn't a decision on the last appeal. We just remanded it. But even if you consider that a decision, there wasn't a decision on the case or controversy, which is what started in the district court and is still ongoing.
I don't think that conception of case or controversy really fits with all the rest of the text in subsection in 46C, because the statute doesn't just speak of case or controversies in the abstract. It talks about how cases or controversies shall be heard and determined by this court, and then it tethers throughout the statute the notion of a hearing and a decision, and even the first provision that talks about when senior judges can participate because they were in a panel, an earlier panel. It contemplates that you're reviewing a particular decision. It has to be a decision that's under review that they participated in.
But let me take you to the last part of the sentence, which nobody's talked about yet. It says, the decision of a case or controversy that was heard or reheard by the court in an en banc at the time when people were not yet senior. So your position is that that final language only, when and it says reheard, heard or reheard, you're fine. So obviously something has happened before under that language. That case or controversy was heard or reheard by the court before, and what you're saying is that language only applies if that prior panel never reached a decision?
Correct. I think it ties together a hearing and a decision. The statute clearly contemplates.
So if we had held on to this case pending Bruen, the panel would be the appropriate panel.
Look, I think that would have been a circumvention of the rule.
Let's assume that we knew Bruen was pending, and so we said we're just going to sit on this case until Bruen is decided. Yeah. The case had not been. Would we be okay to hear it? Wouldn't we?
I mean, if you hadn't issued a decision and a mandate, we'd have a different argument here. I still tend to think the better reading of the statute is, unless you're doing an actual limited remand in the sense of we need you to answer one other question because it's critical to our ability to decide anything.
That's basically what we did. That is what we did.
No, that's not at all what we did. We sent it back to decide the whole case again.
Why do you think this is unusual? We've been doing it this way for over a quarter of a century in countless cases. Senior judges stay on after a remand, either from the Supreme Court or from the district court.
I totally disagree with the premise of the question.
Well, let me go on. Let's take one of our more recent Second Amendment cases, Young versus Hawaii. We remanded it. There was a new decision, and 2 senior judges remained on that panel. In fact, Senior Judge Bybee wrote the majority opinion, and Senior Judge O'Scanlan wrote the dissent. We've been doing it this way for 25 years. I can give you countless examples of that where we've remanded to the district court. It's come back, and even though somebody's taken senior, in the interim, we hear the case with the senior judge.
It's worth noting that Judge O'Scanlan was on the 3-judge panel in Young, so with all due respect to Judge Thomas.
I do recall that. I would simply note,
Well, you take
were asked
DNC versus Hobbs. I mean, DNC versus Reagan, where he was not on the panel, and it came back 2 years later, and it was seated. So
the question for us is that we were asked by this court is whether this is consistent with the statute, whether this court has been violating the statute for a long time or just once.
And every other circuit does it the same way. Every other circuit does it the same way.
Well, every other circuit. Yeah. I mean, this court obviously has a very different dynamic.
I'm sorry. Did you say every other circuit? What?
No other circuit has the same dynamic that this circuit has of not having all active judges participate in en banc proceedings.
Right, we have a limited en banc, but in terms of where the case goes back, who hears it, and whether senior judges stay on it, every other circuit does it pretty much the same way.
Every other circuit doesn't do it our way. That's the point.
Judge Nelson, I'm sorry. You can ask the question, but I think it was asking a question.
I'm responding to a statement by another panel member that's not accurate.
We have had a difficult time finding that there's any rule or anything that contemplates that would be the way that the way this court operates is how it would operate in other circuits. But of course, it doesn't really come up quite the same way.
Well, but it does come up in other circuits. My recollection, and I must admit that it's dim, is that the Second Circuit, although it sits totally en banc, if a judge was on the panel, he sits on the en banc panel, and then when the cases came back to that, they came back to the same panel, including the senior judge. I mean, I may be wrong about that.
I will note that the language, with respect to kind of the hearing and decision and all that, it's different in the provision that deals with a judge who was on the 3-judge panel. That provision that says a 3-judge panel, a judge who was on the 3-judge panel may participate. It doesn't speak about being active at any particular time.
It seems unfair in a Second Amendment case to make you spend 10 minutes on this, but we made
I find it fascinating.
We made the other side spend 10 minutes on it. But I'm interested. So you think that there's a different? So let's assume a judge was on the 3-judge panel, and by virtue of that was on the en banc court, and then exactly the same thing happened. Your view is that judge would be able to serve.
So I think the best reading in that circumstance is that they can't, because their decision is no longer under review when you get to the comeback case. But if their decision still is under review, if they stay on, it goes back to a 3-judge panel and all that. But that first provision specifically ties it to the decision that's being reviewed. So, it just is going to depend a little bit on the factual circumstances. But the second provision very specifically ties it to being active when the hearing takes place. And this case is being heard en banc right now.
Let me ask Judge Ikuda, do you have any questions for counsel?
No, thank you.
Thank you very much.
Thank you.
So we went over, so I'll give you 5 minutes total.
Thank you, Chief Judge McGee. I'll try not to use all that time. I'd just like to make 3 quick points about the Second Amendment. Understanding of the Second Amendment that you've heard from plaintiffs today and in their briefs can't be squared with precedent, and it's not supported by history. So first point, in plaintiffs' view, at the first stage of Bruen, anything that fits their definition of the word arm is presumptively protected by the Second Amendment without any other consideration of objective characteristics or dangerousness. So we're not just talking about large capacity magazines, mind you, but M16s, sawed-off shotguns, hand grenades, all presumptively protected. But Bruen is clear on this point at pages 32 to 33 of the opinion that a plaintiff at least has to satisfy the common use for self-defense inquiry before any weapon is presumptively protected. And Heller said you have to examine the character of the weapon and whether it's a self-defense weapon, and that certain types of weapons like M16s are not eligible for protection. That's based on history and the original public meaning of the Second Amendment, which codified a pre-existing right that plainly excluded certain types of weapons. Second, at stage 2, plaintiff's view is that the only question that a court can ask is the number of a particular device that's possessed today by civilians in states that don't prohibit it, and if that number exceeds a certain threshold, then the device is categorically protected, and every state law banning it suddenly becomes unconstitutional. Again, without any history, my friend said, without any consideration of history or objective characteristics. And I'd note, I think it's very surprising, since this is sort of the sole determinative factor that plaintiffs point to, that they haven't said what that threshold is or even how a court would go about determining it. But what they've suggested in the past is that maybe it's around 200,000, which would mean if 1 in every 1,600 Americans possessed this device, it would satisfy their test. Your Honors, if that were the law, then the Supreme Court absolutely would have considered the numbers of sawed-off shotguns and M16s before it announced that those weapons are unprotected and may be banned. And if the focus really is on history, then plaintiffs would need to identify some historical evidence supporting their view that the government may only ban exceedingly dangerous weapons when those weapons are exceedingly rare, and that those bans somehow become impermissible when the weapons become sufficiently prevalent that they start to create actual real-world problems. Your Honors, the actual history from before and after the founding shows exactly the opposite, that especially dangerous weapons and devices were heavily regulated and banned after they became numerically prevalent. And my last point, I think...
What is your best example of that?
Well, Your Honor, I think that if you want to look before the founding, you can look at crossbows. If you want to look after the founding, in the kind of relevant early 19th century period, slungshots and Bowie knives are prime examples. And the last point I'd just quickly make, perhaps because of their choice of how to argue this case, you haven't heard much of anything from my friends in their briefs or today about sort of the actual characteristics and dangerousness of large capacity magazines.
Doesn't that go into the how and why analysis by which trigger, which informs our understanding of what regulation is relevantly similar? I haven't heard any of that discussion here today.
Sure, Your Honor. I'm happy to address that in the time that I have remaining.
But it seems to me very relevant because there is no regulation on point. So we have to look to regulations that are relevantly similar. And doesn't that require us to look at how and why these weapons are actually used?
I think that it does, and take a nuanced approach because we're dealing with a dramatically new technology and unprecedented societal concern. And if we look back at the historical precursors, we see a number of instances over time where governments have regulated heavily or banned the possession of particular types of weapons or devices that are especially dangerous and pose a dire threat to public safety.
That's why the numbers, the sheer raw numbers, is not really that relevant in terms of the Bruen analysis.
I don't think it's sufficient, Your Honor. I think that Heller talked about numbers and subjective preferences, but it didn't make that the only thing that a court has to look to. I see that my time is up, and with that, Your Honors, we'd ask the court to reverse the district court's judgment and remand for entry of judgment in favor of the Attorney General. Thank you.
Mr. Mongan and Ms. Murphy, thank you so much for your helpful oral arguments today. This is obviously a very significant case for us, and we appreciate the answers to all the different questions that were presented. Thank you very much. We are adjourned.